goes. This is Chicago's Morning Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here. We have a number of legal matters to go over. I mean, for those interested in the rule of law, not everybody is, as we've seen, I understand. I am. I think most of our listeners are. Jay Powell is the Fed chairman. Trump was less than complimentary in the direction of Jay Powell during his remarks to business leaders in Detroit yesterday.
In the Fed, we have a real stiff in the Fed, but that's for another day.
Yeah, real stiff in the Fed. Do we have a stiff and a potential felon as Fed chairman? Of course, relating to the DOJ subpoenas pertaining ostensibly to the $2.5 billion renovation of Fed digs in D.C. That occurred late last week, and Jay Powell issued this statement. This is in pertinent part in response to a DOJ investigation. It's the criminal variety because that's the investigations that DOJ does.
Good evening. On Friday, the Department of Justice served the Federal Reserve with grand jury subpoenas, threatening a criminal indictment related to my testimony before the Senate Banking Committee last June. That testimony concerned in part a multi-year project to renovate historic Federal Reserve office buildings. I have deep respect for the rule of law and for accountability in our democracy. No one, certainly not the chair of the Federal Reserve, is above the law. But this unprecedented action should be seen in the broader context of the administration's threats and ongoing pressure. This new threat is not about my testimony last June or about the renovation of the Federal Reserve buildings. It is not about Congress's oversight role. The Fed, through testimony and other public disclosures, made every effort to keep Congress informed about the renovation project. Those are pretexts. The threat of criminal charges is a consequence of the Federal Reserve setting interest rates based on our best assessment of what will serve the public, rather than following the preferences of the president.
For more on this and a whole range of other legal matters, pleased to be joined again by Andy McCarthy, former Chief Assistant U.S. Attorney for the Southern District of New York, that's Manhattan, contributing editor at National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thanks as always for being with us.
Dan, it's my pleasure.
So let's start with Jay Powell and this look-see into the $2.5 billion renovation, bumped up against what he had to say when he was testifying under oath before Congress. Your review of this review of Jay Powell?
Well, I mean, he's obviously right that it's pretextual. Yeah, the interesting thing is that if you go back to like the 1970s, the Justice Department and the executive branch in general never threw its enforcement muscles behind a congressional inquiry because Congress has lots of powers of its own. It can hold people in contempt. It can hold
like Bill Clinton.
More hearings. Bill Clinton and others, but that actually, I don't think the Clinton thing was, my recollection was that was out of Starr's investigation more than out of a congressional investigation.
No, I mean currently he's looking at that possibility.
Oh yeah, well that's well, we could talk about that, but let me just finish with Powell.
Yeah.
I think there were almost no such investigations until the Mueller probe began to politicize this. They basically were, scrubbing or scouring the earth to find anything they could charge against people like Roger Stone and other people around Trump. And one of the things they looked to was congressional testimony. But at least with respect to that, some people in Congress were asking for an investigation. Here, nobody in Congress is asking the Justice Department to investigate this. They've just, they've plucked it out because, Trump is trying to put pressure on the Fed to lower interest rates, even though, probably interest rates should be a little bit higher than the inflation rate, and it might be, the reason Powell and the rest of them haven't lowered the rates is they're not trying to switch Trump. They're basically they don't want the economy to fall into inflation again. But that they shouldn't be using the Justice Department for that kind of stuff. And I think no one is more upset about this than Bessent, because he had a plan for how they were going to ease Powell out of there and try to get Trump 2 picks on the Federal Reserve Board, and now it looks like that plan is up in smoke because they've made it acrimonious.
Yeah, I mean, we've talked about this many times, but it just seems to me this is, erring on the wrong side of the ledger, where you're trying to affect some accountability against purveyors of lawfare. And I'm not saying Powell was one; obviously, he was in that position.
Yeah.
But the just as we've discussed before in the context of Comey and Letitia James and Schiff and so many of these bad actors. And if we can get Capone on tax evasion, then we'll take it. But you actually have to have the chops on the tax evasion claim. And it seems like in some of these instances, you don't have the chops, and so that and when you do that, you think you're maybe you're thinking the process is the punishment. At least we're getting this, but it further exacerbates people when they think, oh well, they must have a case because they brought it. It doesn't go anywhere, and then they say even when we bring a case, we can't get it done, and it sort of actually boomerangs on you and increases the frustration. It doesn't. People don't take away. Oh, we got our half a pound of flesh instead of a pound.
Yeah, that's a good point. And the problem is that it's a cycle that feeds on itself, right?
Yeah.
So nobody ever says this is really self-defeating. Like every time we do this, we don't really have cases. With the Capone example, the best thing about doing that was that it was Capone. You actually had a murdering madman mobster. And as bad as you think some of these political actors are, they're not Al Capone, right? So you don't really have the underlying reason to do this in the first place. But using the Justice Department as a political tool, no matter who does it, not only almost never works in terms of advancing the public interest. All it does is incentivize the other side that next time we get in charge, man, you are going to feel it. And you can already hear the Democrats saying that. So it's like an endless cycle.
I want to get your view on the arguments before the High Court yesterday, oral arguments in the boys playing girls sports case, these Idaho and West Virginia laws prohibiting boys from playing girls sports, challenged by the ACLU with their plaintiffs in the case, and this exchange between Alito and the ACLU lawyer representing the named plaintiff.
Well, to pick up on the issue of discrimination on the basis of transgender status, let me just go to some basics. Do you agree that a school may have separate teams for a category of students classified as boys and a category of students classified as girls?
Yes, Your Honor.
If it does that, then is it not necessary for there to be, for equal protection purposes, if that is challenged under the Equal Protection Clause, an understanding of what it means to be a boy or a girl or a man or a woman?
Yes, Your Honor.
And what is that definition? For equal protection purposes, what does it mean to be a boy or a girl or a man or a woman?
Sorry, I misunderstood your question. I think that the underlying enactment, whatever it was, the policy, the law, we'd have to have an understanding of how the state or the government was just understanding that term to figure out whether or not someone was excluded. We do not have a definition for the court. And we don't take issue with we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth-sex males categorically from women's teams, and that there's a subset of those birth-sex males where it doesn't make sense to do so according to the state's own interest.
Well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes?
I think here we just know we basically know that that they've identified pursuant to their own statute, Lindsay qualifies as a birth-sex male. and she's being excluded categorically from the women's teams as the statute. So we're taking the statute's definitions as we find them, and we don't dispute them. We're just trying to figure out, do they create an equal protection problem?
All right.
So, Andy, the age-old philosophical question that remains unanswered, like what is consciousness? Why is there something rather than nothing? What is a woman? These questions persist.
Yes, I guess they do. Well, I guess I'm of two minds about this. First, I understand the lawyer's trying to argue a position. You can hear how tremulous her voice is when she's answering these questions because they're like the basic question, and she doesn't really have a good answer for it. But like the analogy I would make to you Bears fans out there is if we were going to make a rule that said a first down is 10 yards, and Justice Alito came and asked the head of the NFL referees, well, what's a yard? You guys have a definition of a yard? And they said, well, we haven't figured that out yet. We'll get to it. His point is you can't make a rule about a category unless you can define the category. It's like it's completely pointless.
A yard is whatever Caleb Williams says it is, Andy.
Well, it's nice to have a quarterback. I say here from the New Jersey area. But I think the other thing that disturbed me about the argument writ large is I've always just been of a mind that once you think you have to add adjectives to basic terms, you've lost the argument. That it's just, basically at that point everything else is about details and how long it takes you to lose the argument. I thought that, like, for example, the marriage argument was over when they started to think you had to call it traditional marriage, as if there was because then you're saying there's other kinds implicitly. And looking at the transcript, I didn't listen to the argument, but looking at the transcript afterwards, I was very surprised to see Justice Barrett basically accept the terminology of the trans activist. So she talked about boys who identify as girls, as trans girls, and at one point she talked about a cisgender male, I think. And I'm thinking, if I'm now a cis male instead of a male, then the argument's over. It may take a year, it may take 3 years, but once you start to think that you have to add adjectives in order to clarify basic terms that we all used to understand naturally, then I think you've lost.
And not to mention Neil Gorsuch in the Comstock case sort of provided a glide path to expanding the categories of protected classes when it came to identified. So I mean, what are you suggesting that this could go the way of invalidating the laws in West Virginia and Idaho and similar laws around the country?
I think what this court remains good at, even though the left, of course, distorts this, is that I've always said that left. There's a big difference between left-wing judges and right-wing judges. Lefty judges, progressive judges, they figure out what the progressive result needs to be, and then they reason backwards whatever they have to do. So one day they'll be textualist, and the next day they'll be making it up as they go along. But they know what result. They want to give you progressive results. Originalist judges, conservative judges, what they want is the right part of the government or the right part of the society to make the decision. They don't give you conservative results. They give you kind of a conservative procedure consistent with what the understanding of our government is supposed to be. And what I think this court will do, as it's done in a lot of these cases, is not decide the substantive issue, but say the states get to do this, which means if the people of a state want to vote it one way, they can do it one way. If they want to do it the other way, fine. I don't think the court is deciding long-term societal trends. And what I'm interested in this particular is a long-term societal trend. And that's why I just think, having just watched this routine and watch how the left uses language for decades, this is how it starts. The minute that you think you understand something, but then they convince you that you need to modify it with an adjective so that we can clarify it. And that's always because they're trying to take something that's basically true and dismantle it.
Yeah, but the state, like I definitely see where you're getting at, and that makes sense. But as a framework, the problem is that framework really doesn't work because much like collegiate sports, even high school sports now cross state lines, and so you're still going to run into these same problems if you don't offer that definitional clarity that Alito was seeking.
I think that's right, but I also think, if you're asking me what I would rather see the court do, I would rather see them take on the main issue and decide it.
Yeah.
If you're asking me what this court is going to do, I think they elevate collegiality over deciding the main question, and if they can blur the lines a little bit to get a 7-2 decision rather than a 5-4 decision, that's what they'll do. And what they would say to you, Dan, is we'll wait for the next case for that one. We're just going to decide as narrowly as we can the one in front of us. And if the cross-state lines thing ends up being an issue, that'll be another case, and we'll deal with it when it comes.
I did want to get your take on the ICE-involved shooting in what was formerly known as Minneapolis, Renee Good. A local retired police lieutenant who's a friend of the show is a good example of what has surprised me a little bit. Some law enforcement, people on the center right that are inclined to be supportive of law enforcement, suggesting that the shooting of Renee Good was not a legitimate self-defense shoot. What our friend says to local news here is, I'm quoting him, retired Chicago police lieutenant, she first cuts her wheels to the right, and then when she backs up, it actually repositions her car, now facing him. He doesn't move that much. Her moving the other way is what brings him dead center on the driver's side of the vehicle, and when that happens, it's all a split second. Normally, you wouldn't want to be standing in front of a vehicle. The vehicle backs up, and the front of her car realigns and repositions, and that's how he ends up where he is. Unfortunately, when you get rhetoric from Kristi Noem or from the president, when it sounds like this is an open and shut case, it's all a done deal, that affects the impacts on public trust. Well, I have to disagree with my friend, and this is why I want to get your adjudication of this disagreement, because, at the end of the day, the bottom line question, regardless of, I'm not saying Renee Good is a domestic terrorist, and I think that was an unfortunate choice of words by Kristi Noem, but I am saying that her mens rea doesn't matter. What matters is whether or not that ICE officer had a reasonable fear for serious bodily harm or death, and he did, and she was facing him, and he had his gun trained on her, and then she moves the car in his direction. What are you doing?
Yeah, well, I've said all along, I think that what people have to realize is that the narrow question here, and it really is very narrow, is whether he had a reasonable perception of imminent serious bodily injury or death. And he did. I think he did. And also layered on top of that is that the case law is going to give an agent or a police officer more leeway when the issue is an automobile that's moving as opposed to like an on-foot confrontation, because automobiles are inherently dangerous in that context, and many bad things have happened to agents and police officers in vehicle stops. So I think as a matter of law, he has what I would regard as an ironclad defense. Now, where I think the administration is going wrong is if there's a normal process by which if agents are involved in agent-involved shootings, and especially if somebody dies, they do an investigation.
Yeah.
And I think they should go ahead and do what they do with the idea that the agent is going to be cleared. But the idea that they're not doing that, and at the same time, like they're investigating Good's partner, I mean, what's the point of that? That's just, moronic. And it just gets everybody more stoked up. This ought to be something that's handled by the book. And there should be no problem about having the state involved in the investigation if that's what they would normally do, because if the state tried to do something wild and crazy, like charge this guy with murder, they would easily be able to move the case into federal court, and then he'd have all his federal defenses, including immunity and the fact that the shoot was a righteous shoot. But I just think they ought to do it. But when somebody dies, you got to do it by the book.
Yeah, no, I agree. And it more so, in terms of the trying to focus people's attention on what matters here legally, which you just did nicely, especially in the wake of arguments like, she was trying to leave. Well, she doesn't get to leave. When I get pulled over for speeding, I don't say, okay, I hear what you're saying, officer. I sped. I'm going to go now. That's not how it works. And everybody knows this, but we have like this suspension of disbelief, like she was just trying to leave. You have ICE officers issuing lawful orders. You got two on the driver's side. And so this guy comes around the passenger side in front of her to stop her from leaving because she's non-compliant. I mean, this is not like complicated.
No, it's not. In fact, I hate to point this out because I don't see the need to continue to pile on good, but the left is making this necessary. So she committed the most serious grade of the crime of assault on a federal officer. I had a number of cases when I was a prosecutor back in the paleo age where I had a case involving a probation officer where all the guy did was clench his fist and make like he was going to hit him, but didn't hit him. That's assault because the statute says assault, intimidation, or interference. To make out assault, you don't need battery. And the statute has grades of seriousness. So the kind of crime I had was like a misdemeanor because nobody actually got hurt. If you do an assault on an officer with a dangerous or potentially lethal weapon, which a car is in this context, that's a 20-year felony. And she didn't just put him in fear. She actually struck him with the vehicle. Now, it was a swipe. I don't think he was seriously injured. But I think she actually assaulted the first officer, too, technically speaking. The guy who was at the window on the driver's side of the car.
Yeah, she starts to pull away.
The cop is holding your window. Yeah, that's an assault. If nothing had happened here, like she hadn't been shot, she had just been apprehended, she would have been indicted for assaulting two federal officers, and it would have been, I'm not saying she would have gotten 20 years if nothing else had happened and nobody had gotten seriously injured, but they would have charged her with a 20-year felony. So she doesn't get to leave. It was stupid for the administration people to talk about domestic terrorism because we actually, let's not trivialize that. We have jihadists who drive cars on the street trying to mass murder people.
Right.
That's not what this is. But it was easily assault on federal officers. So you don't get to leave after you've committed a felony. I'm sorry.
Andrew McCarthy, former Chief Assistant U.S. Attorney, Southern District of New York, that's Manhattan, contributing editor, National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thank you as always.
Thanks, Dan.
All right, now we check the headlines.
Good morning. It is 32 degrees here in Chicago on AM 560. The Answer. I'm Stace Keene in the